My nice tie.
Monday, May 13th, 10:03. We'll call this meeting to order the Podiatric Medical Examiners Advisory Board. Just housekeeping things. If you're not talking, hit your mute button. It will be right next to your start and stop video button. And it helps with some reverb noises that we can call out when we do that. When you're speaking, please, although we can see your names on the video screen, just state your name before you start talking, and then we'll do our best not to talk on top of each other. That was agenda item A. Agenda item B is a roll call. Angelica, can you call the roll, please?
Yes, sir. Dr. Campbell?
Here.
Dr. Brown?
Here.
Dr. Lunsford?
Here.
Dr. Martin?
Here.
Dr. Peach?
Here.
Kristen Lucky?
Present.
Yvette Hernandez? Sirenia Terrazas?
Here.
And presiding officer, Dr. Motley.
Here.
You have a quorum, sir.
Okay, thank you. And special welcome to Kristen Lucky joining us. We used to have much more frequent meetings than this, but just the way things work now, we don't have to have an awful lot of meetings, which is a good thing, but we're awfully glad to have you. And thanks for joining us.
Yes, of course. Thank you all so much.
Yeah. Is there anything you want to tell the group about? It's not like, you have to tell us your 5 favorite foods or anything, but anything you want to share?
I'm from the Rio Grande Valley, recently with Marine Military Academy down here in the Valley, just recently left, and I now work as a PR for Congressional District 34 campaign. So.
Very interesting. Love it. Okay. Thank you, Ms. Lucky. Advisory agenda item number C, advisory board member training. Mr. Parker, do you want to hit those required things?
Yeah, thank you, Mr. Chairman. Yes, my name is John Parker. I don't think I've had the chance to meet most of you, but nice to meet you. If you guys ever have any questions, you can always reach out to me, Halika or Anna, and we'll get back to you as quickly as we can. So yeah, now I'm going to share my screen. Let's see. Halika, can you see that?
Yes, sir.
Okay, great. So before we get into the fun stuff with the rules, we're going to have to do some required training. So try to stay awake with me and bear with me on this. Open government training. We're going to be talking about the Open Meetings Act, the Administrative Procedure Act, and the Public Information Act. We're going to start with the Open Meetings Act and nuts and bolts. The purpose of the Open Meetings Act is to ensure open and transparent government. The Act requires meetings of governmental bodies to be open to the public and to be preceded by public notice of the time, place, and subject matter of the meeting, just like today. The provisions of the Act are mandatory and are to be liberally construed in favor of open government. So a key concept is a quorum. A quorum is a majority of the members of the advisory board or committee as fixed by rule or statute. A quorum of a governmental body, including an advisory board or committee, must meet in order to take an official action. So as we just did the roll call, we have a quorum today, so we can take official actions today if we do that later in the meeting. If less than a quorum meets, the board or committee may have a discussion but may not take any official action. Another key concept is deliberation. Deliberation or discussion means a verbal or written exchange among a quorum of a governmental body or between a quorum or a governmental body and another person concerning an issue within the jurisdiction of the governmental body. Meetings is another key concept. A meeting occurs anytime a quorum of a governmental body engages in deliberation regarding public business or public policy over which the governmental body has supervision or control, or anytime the body takes formal action. So today, this is going to be a meeting. Another key concept is notice. As I just alluded to a second ago, the Act requires advance written notice of the date, time, place, and subject of each meeting held. TDLR provides this notice in the form of an agenda. Notice must be filed with the Texas Secretary of State at least 7 days before a meeting and must be posted online, both by TDLR and the Secretary of State. A board or a committee may not engage in discussions about a subject not included in the agenda. So one of my roles today, I have the agenda that we're going to be following. We have to stick to those topics. If we start to drift off, I'll try to bring us back on board with whatever's listed on the agenda. So what about social functions, conventions, and workshops? So question is, keeping in mind that a meeting occurs whenever a quorum engages in discussion about an issue within the governmental body's jurisdiction, can members ever meet in an informal setting without violating the Open Meetings Act? And the answer is yes, of course you can. Members are free to engage in conversation that is incidental to the event. However, the discussion will be subject to the Open Meetings Act if a quorum of members is involved and the members either engage in a discussion or make decisions about board or committee business or take formal action. So just keep that in mind. Of course, you guys are welcome to talk to each other and talk about incidents incidental to the event. But if we're going to have a formal discussion about actions that we should be taking, we should limit that to public meetings. So some key points to remember: always be aware of any situation occurring outside of a properly noticed meeting in which a quorum of members is present or engaged in discussion. Do not engage in any substantive conversations relating to board or committee business or policy when a quorum is involved and you are outside of an officially noticed and scheduled meeting. And then beware of the walking quorum. The walking quorum occurs when fewer than a quorum of members engage in discussion about official business and then communicate those discussions to other members. While fewer than a quorum of the members participate in the initial communication, subsequent communication with other members will result in a quorum discussing official business outside of a public meeting. So here's an example. On a 5-member advisory board, 2 members exchange phone calls and emails expressing thoughts on an upcoming rule change. And they exchange research that they've each individually performed regarding that issue. One of the board members subsequently forwards the exchange to another member. The members have now engaged in a walking quorum by engaging in a small group discussion outside of a properly noticed board meeting. So walking quorums can occur during conference calls, video conferences, hallway discussions, emails, texts, and other new technologies. The walking quorum concept combined with newer technologies such as Twitter, Facebook, and instant messaging raises new issues about meetings and compliance with the Open Meetings Act. So if you guys are going to be talking to each other, just keep that in mind that we want to avoid the walking quorum. Some best practices to avoid a walking quorum: members should not meet in small groups, discuss board or committee business, and then communicate those discussions to other members. Members should not send emails or text messages to a quorum of members regarding official business, even if each email is addressed and sent to each member individually. Members should not create posts on social media about board business where a likelihood exists that a quorum of members could participate in discussions, and that members should not ask a quorum of members, even on an individual basis, for feedback or comments on board or committee business outside of the public meeting. This is also called polling, which is essentially conducting an informal vote on an issue. So a few guidelines for open sessions. A board or committee is limited to discussing specific items on the agenda. During the public comment portion of the meeting, members of the public are given an opportunity to speak, and the presiding officer may set reasonable limits on the commenters. I don't think we have any members that are going to be giving comment today from the public. A member of the public or a member of the board may raise a subject that has not been included in the agenda. However, any discussion of the subject must be limited to a proposal to place a subject on the agenda for a future meeting. So again, if there's something that we want to talk about that's on the agenda, we're going to have to table it, and we'll be sure to include it on a future agenda. Here's some best practices for open sessions. To avoid violating the act on the basis of insufficient notice, members should limit discussion to the specific agenda items contained in the posting filed with the Secretary of State. You should avoid allowing discussions regarding specific agenda items to wander off course into new issues that have not been noticed to the public. Members should not respond to or discuss issues that are raised during public comments, but which are not on the agenda. Again, that won't apply today. And members should specifically identify items for future agendas and communicate those items to TDLR staff. There are some penalties and remedies for Open Meetings Act violations. There are civil remedies. Any interested person, including the media, may petition the courts to stop actions taken in violation of the Open Meetings Act. The Open Meetings Act also specifically states that an action taken in violation of the act is voidable. There are also criminal penalties. Members who knowingly participate in a walking forum or who knowingly participate in a meeting that is closed to the public are subject to misdemeanor criminal penalties. The penalties are a fine of $100 to $500, confinement in county jail for 1 to 6 months, or both the fine and jail time. So we want to avoid that. Some more best practices: avoid communications that involve a quorum of board or committee members about official business outside of a properly noticed public meeting during open meetings. Confine discussion to items specifically posted on the agenda. There are some resources on this PowerPoint, and we can go ahead and send you this PowerPoint after this meeting if you guys would like. If you want to do some more research on your own, here's some helpful links. But of course, I'm available if you guys have questions. You can always reach out to me and I'll get back to you. So now we're going to move on to the Administrative Procedure Act. The purpose of the APA is to establish minimum standards of uniform practice and procedure for state agencies and provide for public participation and transparency during the rulemaking process. So the definition of a rule is a statement of general applicability made by a state agency that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of a state agency. A rule excludes a statement regarding only the internal management or organization of a state agency and not affecting private rights or procedures. A rule includes a new rule, an amendment to an existing rule, and the repeal of an existing rule. Some sources for rulemaking: there's some legislative changes, advisory boards, TDLR staff, 4-year rule review, and rule petition. So today, this meeting is because we're having the 4-year rule review of the pod rules, and so we'll get input from you guys, advisory board and TDLR staff. And so those are just some examples of sources for rulemaking. A rule petition: any interested person may submit a petition to a state agency requesting the adoption of a rule. An interested person is anyone who is a Texas resident, a business entity located in Texas, a governmental subdivision in Texas, or a public or private organization that is not a state agency but is located in Texas. So here's a brief flow chart of how the process works. You start with rule idea and drafting. We have some internal review and analysis. There's a review by the governor's office. So the rules package that we're going to be reviewing today is still with the governor's office. They're reviewing it, but that's fine. We shouldn't get any substantive feedback back from them. But after that is when we are supposed to have our first advisory board meeting. So that's where we are today, our first advisory board meeting. And then after that meeting, the proposed rules get filed with the Secretary of State. We post some plain talk summaries. and then it gets posted in the Texas Register. There's a 30-day public comment period. After that comment period closes, we'll review the public comments, and then we'll have a second advisory board meeting to discuss any future changes that may need to be made. And then after that, we bring the rules package to the full commission itself, and the commission will hopefully vote it up, and then there will be an adoption notice filed with the Secretary of State and published with the Texas Register, and then the rules go into effect. So that's the process that we're working with today. Here's another flow chart that kind of describes the same process. This program, Podiatry, is on a 4-year schedule. Every 4 years, there's a review of the rules. TDLR publishes a notice of intent to review. Again, the public has 30 days to comment on that. General counsel reviews any comments and makes recommendations, and the commission reviews the rule filing and comments and may re-adopt the rule, and then we meet with advisory boards. So those are just two flow charts of the process that we're talking about when we're dealing with the APA. So again, for the APA, there are also some more helpful links if you guys want to do some more research on your own, but again, I'm available to answer any questions. And then lastly, we have the Public Information Act. The Public Information Act, or Open Records Act, is intended to allow public access to information about the affairs of government and the official acts of public officials and employees. The Act makes all documents, records, and other information relating to official business open to the public, with some exceptions. Public information includes any electronic communication created, transmitted, received, or maintained on any device if it is in connection with official agency business. The Act should be construed liberally in favor of granting requests for information. So requests for public information, the public may request copies of public information or request to inspect the information in the offices of the governmental body. A request must be submitted in writing. At TDLR, a request must be submitted through the TDLR Record Center, which can be accessed on the TDLR website. And a key concept is a prompt response. TDLR must respond to the request as soon as possible, but not later than 10 business days after receiving the request. We cannot ask someone why they want the records. We can only ask for clarifications through the General Counsel Open Records team. So general rule and common exceptions to disclosure. The general rule, again, is a presumption of openness. Certain information is required to be redacted from open records. These examples include date of birth, most email addresses, driver's license number, license plate number, VIN records, credit card numbers, HIPAA information, and Texas Medical Records Privacy Act. The Attorney General's Office ruling must be sought to redact or withhold other information. If a board member, if one of you receive a request for public information, as an advisory board member, if you receive a written request for records or correspondence that looks like a public information request, please forward the request as soon as possible to the advisory board team, who will forward it to the Office of General Counsel Open Records team. If the GC Open Records team requests information from you as an advisory board member, please respond as quickly as possible. The 10-day business deadline applies to all requests. So again, there are more links if you guys want more information on the Public Information Act, but if you just have questions, you can always reach out to me and I will answer your questions. So that is all I have for this presentation. Now I will turn it back over to Angelica.
Real quick, Dr. Motley, I do see Ms. Hernandez, I'm sorry, popped on.
Perfect.
Ms. Hernandez, I know you're having difficulties with your camera, but do you want to try it real quick? And can you hear us? Ms. Hernandez, can you hear us? Anna, do you want to get with Ms. Hernandez real quick? See if we can't get her situated. I'm not sure if she can hear us. Dr. Motley, if you want to move on to the minutes.
Yeah. Okay.
So, we'll
Mr.
keep working
Parker.
with her.
Okay. Great. Thanks for doing that, Mr. Parker. I remember a long time ago, that was almost a full day and a half of sitting in a meeting room. So this is a much better way of doing it. That was agenda item C. Agenda item D, approval of the minutes. So everyone should have their minutes that were sent to you from our last meeting way back October 4, 21. If we don't, any comments on those before we vote? Otherwise, I'll take a motion to approve those minutes.
I'll motion to approve. Second.
Can I get who made the motion? I apologize. Is that Dr. Lunsford?
I think it was Dr. Lunsford and Miss Lucky, maybe.
Thank you.
All right. And then I guess since we can't do it by ayes or nays, do you need to do a roll call vote?
Yes, I'll go and do that real quick. All right. Dr. Campbell? Approve. Dr. Brown?
Approve.
Dr. Lunsford?
Approve.
Dr. Martin?
Approve.
Dr. Peach?
Approve.
Kristen Lucky?
Approved.
And Ms. Hernandez, if you can hear me, do you approve of the minutes? And Serenia Terrazas?
Approve.
Motion passes.
Perfect. Thank you for doing that. That was agenda item D. Agenda item E is public comment. We did not receive any comments, so we will go to agenda item F, which are staff reports. So we'll start with licensing division and statistics. Ms. Horton.
Yes, good morning, advisory board members. My name is Regina Horton. I'm the team lead for the health professions licensing team, and I will be providing the statistics report for podiatry. You should have a copy of the report in front of you. So for second quarter fiscal year 2024, we issued a total of 13 new licenses and we renewed 28 licenses. We had a total of 27 licenses that renewed online with a percentage of 99. The total population was 1,213. For the podiatric medical radiological technicians, we have for second quarter fiscal year 2024, 17 new licenses were issued, and then we renewed 60, a total of 60 licenses renewed with a population of 192. And that concludes my report. Do you guys have any questions?
No.
Okay, thank you. Have a good day.
Thank you, Ms. Horton.
You're welcome.
Agenda item F2, Ms. Martinez Castellan for customer service.
Good morning, advisory board members. I'm Patricia Martinez Castellan, the customer service manager over the podiatry program, and I'll be sharing the statistics for fiscal years 2023 and 2024. Our report shows the number of contacts received throughout the months, fluctuating due to external trends such as graduation, new applications, and renewals. You'll notice that we don't have much data for emails, and this is because any emails pertaining to podiatry are automatically routed to the respective licensing team for assistance. And that concludes the customer service division statistics report. Please let me know if anybody has any questions.
Okay, thank you very much. Mr. Pettis, Enforcement Division.
Yes, good morning. My name is Pedro Perez Jr. and I am a prosecutor in the Enforcement Division. I'm here to provide you with the enforcement report. For those of you that were here at the previous meeting, Karen Cox is the one from Enforcement who provides the report. She has since retired, so it is me who's giving the report. First, you may notice that we've updated the Enforcement Division report format from our last meeting. As we get started, I want to refer you to the top of page 1, where you have the division's performance measures. This is the type of information which is reported to the Texas legislature. You may notice that we've also reorganized materials so you can compare one fiscal year to another fiscal year more clearly. The materials are organized so you can compare fiscal year 2023 to fiscal year 2024 through February of each fiscal year. For this report, we're looking at a 6-month period. You may notice that we open and close the same amount of complaints, which is 13 so far in fiscal year of 2024. But I will note that this program overall does not have a lot of disciplinary action. The next section is the criminal history review for applicants who may have disqualifying criminal history. These cases are handled by criminal history prosecutors. I do want to highlight that applications for a license by persons with a criminal history have decreased slightly between fiscal year 2023 and 2024. The next section deals with where enforcement division's complaints come from, whether they are from consumers or from within the agency. The top of page 2 puts into a pie graph chart the number of cases opened and their source through fiscal year 2024. All 13 of the complaints opened this fiscal year 2024, have come from a consumer complaint. The next section details our caseloads within our enforcement division. You can see the caseloads for the Department for Podiatrics in this section. The next section is the ordered issue section. This section includes the different types of orders that may be used in podiatric cases by enforcement. The penalties and consumer remedy section details how many fines were assessed versus actually collected and shows you the average penalty on these cases. There have been none for fiscal year 2024. Next, there have been no licenses with disciplinary sanctions so far for fiscal year 2024. The next section is the cases closes without disciplinary action. Enforcement's goal is not only to collect fines, but to try to gain compliance with the laws and rules for this program. When a licensee is able to take corrective actions, sometimes the case can be closed and informally resolved. There are also cases which may have been investigated and are closed as insufficient evidence of a violation. The next section details alleged violations at opening. These are just the reasons the case is open on the front end. The following section details violations which resulted in this disciplinary action. These are topic cases we took action on. So far in fiscal year 2024, as you can see from the report, the number is 0. Next, I have highlighted for you one case highlight on page 3. This is a summary of a case that enforcement worked on in the past. Finally, at the bottom of page 3, I wanted to mention a project that the Enforcement Division has been working on, case prioritization. In particular, as a result of the Department's sunset review, the Enforcement Division is establishing and assigning priority levels to complaints that are filed, and the priority is based on the risk of harm to the public. This process is intended to put the focus of our limited resources on the complaints that have the greatest impact on health and safety. This is the end of my presentation. If you have any questions, I'm available to answer any questions at this time. Thank you.
Any questions for Mr. Pettis? I have one going back to average time to close a complaint, and this goes back, I don't know, 15 years or more. This has always been kind of a point that seems to get brought up as far as time to closure. I mean, even pre-sunset and long time people that have been on the sport a long time know that always seems to be an issue. And so I don't know if you have any ideas. Do you anticipate that number decreasing as far as time to resolve a complaint, or is that, I mean, it's doesn't match the TDLR number, but we're a little bit different than everybody else at TDLR, I'm aware, but do you foresee that number going down as time to resolve those complaints?
I mean, I think there's always an effort made by the division to address these cases as soon as possible. However, you know, for different factors, including different caseloads that the prosecutor may have, sometimes, and as well as the investigative effort that sometimes go into these cases, sometimes it's hard to get to these immediately. However, I do understand your concern, and I will express that to my superiors and let to know that that's an area of some concern for you, sir.
Great. Thank you so much.
I have a question regarding that. What is that number? What is the average number?
251 days.
As I read it, it seemed kind of high. I couldn't remember the exact number.
Yeah, I think we're similar. I don't have any of that old data in front of me, but you know, I do remember sitting in front of Sunset, and that was one of their biggest things was what in the world takes so long. And then one of the goals or anticipated goals and benefits of going to TDLR was that there's much many more available resources that could decrease that time. And that number's never changed over the past 10 or 15 years that I've been doing it, that I can recall. I don't know, maybe anybody else that has a better memory than me may see if that number's changed much. Do you recall any difference in numbers, Dr. Campbell?
No, this is very consistent with the struggle we've been having for years. And I agree, this is dating back prior to sunset. I guess the real question is, what factor really needs to change to change that number? Is it truly personnel? Is it the type of cases that you're looking at? Is that why we seem to be the outlier here?
If I may respond, Chair, I understand the concern, and I will express it to my superiors in my office. I will say that we get a lot of complaints in a lot of different areas. The prosecutors that are assigned to work on this program are not only working on this program, so it's not as if they're only working on these 13 cases. They have other programs that they're working on. So, but however, your concern is noted, and I will make sure to take that back to my office.
Perfect.
Dr. Motley, I know they formed a group of individuals, contracted podiatry individuals that were supposed to be reviewing these cases. Has that really made an impact on the resolution?
Yeah, not that I could tell, but Mr. Perez, I think that may be a question for your office also, that hopefully next board meeting we can have some input on that with this focused group like Dr. Lunsford talking about. That was one of the goals, to help decrease that. We know we're an outlier in TDLR. It's different than elevators and escalators. So we know we're different, but I think some follow-up on that would be great.
Right.
I have a little bit of follow-up, Mr. Perez, if I may. We presented last year during our conference. I have the last 5 years average time to close. So in 2018 it was 128. That's pretty good. And then it's kind of been hovering. During 2021 it went up to like 350, 319. Then fiscal year 2022 is 238 days, and fiscal 23 it was 228, so 10 less days. I think when we were talking to, one of the problems, there's just not a volume of cases, and so some of these cases, if you have one hung up that can stretch over a year and a half, 18 months, that can really bend the number out of proportion.
Okay, makes sense.
Mr. Chair, just so I understand what was asked earlier, I think there was first of all, I don't work in this program. However, I present this report. Just so I understand the question that was asked earlier, my understanding was there was some type of special group that was put together in order to assist in this. Is that what you said earlier, or somebody said earlier that?
That was Dr. Lunsford.
I'm sorry, Dr. Lunsford. Could you repeat what you said earlier, just so I can make sure I note that, so I can ask my office about that?
So as I recall, the board contracted with a number of physicians to review these cases. Now, I understand there's a process before we get to that review, but I'm curious whether their efficiency has contributed as we had hoped for it to.
Okay, I will look into that, and I will have an update at the next meeting. Sure.
Perfect. Thank you very much. Anything else from Mr. Perez? Okay, that was
just a point of clarity, Dr. Motley. I think that there was also, in regard to what Dr. Lunsford was saying, there was a time frame in which one of the groups, or at least several of the groups, were not being provided legal support, and then the governor changed that. So I don't know if that's a confounding factor as well. But there was a time when one of the subgroups was not willing to go out and review cases because of the lack of legal coverage. So I don't know if that was a mitigating factor. I don't know how long that, I don't know if that was a year's course, or the numbers are reflective of that time frame.
Okay, we'll try to get that information also.
And I know that that's been fixed.
Good.
And we
Mr. Chair,
have been
just so I-
recruiting, and as far as I know that, I mean, last time I touched base with enforcement, that we do have enough SMEs available to review the cases. So hopefully that should
Yes,
help.
and thank you, Ms. Eager. I recognize that it was fixed. Thank you.
All right, great. That was agenda item F3. We'll go to F4, education examination. Ms. Pascal?
Good morning, advisory board members. My name is Ann Pascal with the Education and Examination Division, and I am here to provide you our report today. Our report will provide a comparison between fiscal year 2023 and fiscal year 2024. As of March 31st, 2024, the overall pass rate for the exam is at 54.5%. And that concludes my report. I'm available for any questions.
Perfect. Any questions about the examination? All right, we'll go to F5, compliance division. Mr. Eaker?
Hi, everybody. Steve Eaker here with the Compliance Division report. So let's go over what we're doing lately. We've been working with all divisions in the advisory board and work groups on the proposed rules for and answering some questions related to hyperbaric oxygen education requirements. We've also been reviewing the requirements for the RadTech license, looking at increasing the license period to 2 years for the RadTech, HBO, and nitrous license permits, among other changes, and those are going to be gone over by Jonathan shortly. We're also, our work group leads will be giving a report about these work groups today. We've also been working with IT and software contractors and licensing and other agency departments on the successful migration of our licensing program. Our old licensing program, for those who go to the conferences, have already heard this maybe, but for others listening now, it used to be in FileMaker Pro and Tulip, which were some ancient and legacy systems we had at TDLR. It's now been migrated to Versa. So we've worked together to make that license application process work much better. We've created step-by-step SOPs, and that process continues to be tweaked, the SOPs along with our processes and programming. We've found some residual bugs and we fixed those, and we continue to work on the process. We're also now working on a total system for the agency, which will benefit license holders of any license type, because that just means more people with the knowledge to operate the system. Before, when we were siloed, when podiatry was siloed in that legacy FileMaker system, there were like 2 people. I think Hemet knew how to operate it, and another one of the administrative people were proficient at it. Now we have dozens of people that know how to use Versa, which is our current system. So that really helps move people around when we have a real rush on licenses, such as now, as residents are applying for their temporary residency licenses. What else? Compliance staff, we continue to assist enforcement, field inspections, licensing, education, examination, and customer service with questions, as well as addressing daily questions and emails from licensees. We've also been assisting the Office of Strategic Communication, OSC, with website redesign and content layout for multiple health profession programs, and then as well as working with different agencies on the requirements relating to controlled substances for the prescription management program. We're also working on an overall agency-wide audit system to update the continuing education review process, and that is continuing to this day. In terms of outreach, last summer and fall, we were out at the TPMA conference in Round Rock, and we went to the one in the Southwest Foot and Ankle Conference, the regional conference in Las Colinas up in Dallas. We manned a booth at both conferences and answered a lot of questions, and we really enjoy being out there. And we look forward to attending the conferences this year. We've also been working on the health monitor And we just had one come out in March, and we should have another one coming out mid-June, and we'll have articles in that relating to this rule package, should it be approved, and along with other updates on our website as the rule move through their promulgation process. And if you have anything that you feel that we need to take a look at or do some education on, let me know. That's all I got.
Wonderful. Any questions for Steve? All right, thank you. Steve gets my phone calls a lot whenever I have a question. Unfortunately, he's the guy that I have in my cell phone under Quick, so he gets a lot of work. But last one here on staff reports, executive office, Mr. Bruno.
Thank you, Mr. Chairman. Good morning, everyone. Sorry, lost track of the time. My name is Steve Bruno, Deputy Executive Director here at TDLR. And just to build off your previous comment, Dr. Motley, Steve's someone I call as well whenever I have questions about this program. So thank you to him and to our entire team. The last time I spoke with you, I was Government Relations Officer, and about 8 months ago, I became a Deputy Executive Director. We also have another Deputy Executive Director, Brandy Myers. Brandy came to us from the medical board to TDLR several years ago. She was serving as our Chief Financial Officer, and she's also a Deputy Executive Director with me. And then in the Executive Director office, we have a familiar face that's returned. Many of you know Brian Francis. And Brian, in January of this year, following the resignation of Mike Harris-Mendez and then the interim directorship, executive directorship of Christina Kaiser, Brian Francis was brought back for a term of up to 6 months to serve as interim executive director. So we've had a few changes in the executive office, but things are going very well. And we are excited to see you all today and look forward to our future. The commission's going to be meeting on the 21st of May, and I would anticipate some announcements about the executive director position at that time. And I'm here, as always, for any questions or comments from you. Thank you.
Wonderful. Any questions for Mr. Bruno? Wonderful. Okay. Well, thanks for everybody doing those reports. That's what keeps us updated and knowing where we stand and what we're doing. So we appreciate all of those things.
Dr. Motley, real quick, I apologize for interrupting. Ms. Hernandez, can you test your mic for me real quick? I can see you. Just want to make sure you're all good to go. Can you say something? I can't hear you. Just one more. No. Okay. We'll have to come back. I can't hear you. I can see your lips moving, but I can't hear you. Sorry about that, Dr. Motley. We'll keep going. We'll work with her.
Yeah, no sweat. No sweat. That was agenda item F. We'll start agenda item G, work group reports. Education work group, Dr. Peach, you want to give us the update on that?
Sure. Mine is for the radiology. The education and examination work group met via email correspondence and video correspondence and conference in June and July of 2023 to discuss the educational requirements for the podiatric medical radiological technician license. Dr. Martin, a subject matter expert on the subject, provided materials and the history of the program to the work group. The work group then assessed and discussed the changes suggested by Dr. Martin independently. Those changes are included in the rule package for the entire board to consider today. That is it.
Wonderful. Is that something, and how long ago we need to vote to accept that report?
No, sir.
Okay. Great. That was G1, G2 standard care work group, Mr. Rosas.
Good morning, members. The standard of care group, which is myself, Dr. Motley, Dr. Lunsford, and Dr. Campbell, we met via email correspondence in April 2024 to discuss educational requirements to the hyperbaric oxygen HBO license. Work group members considered the changes by the Undersea Hyperbaric Medical Society, the UHMS, decision to allow interactive online education for the 40-hour introductory hyperbaric medicine course, which is the minimum requirement. TDLR podiatry program rules require UHMS approval of HBO licensed courses. Staff reached out to UHMS to clarify the changes and shared them with the work group. The work group agreed that the standard met in a UHMS approved live interactive online introductory course is equivalent to an in-person course. And that is the end of the report.
Perfect. Thank you for that. And that was really just cleaning up and making sure that our requirements met that of the people that are the certifying bodies anyway. Okay, great. Thank you, Mr. Terrasas. That was agenda item GH. We're going to lean on Mr. Parker for this one. There's a lot of new rules. I don't know how if you want to chunk them up or what your proposal is, Mr. Parker, but I'll let you drive from here.
Thank you, Dr. Motley. I think we're just going to go through section by section and just try to talk it through. Most of these changes are streamlined changes. We're moving some things around too, but we'll get into that when we get there. And of course, if at any time anyone has any questions, please speak up. Now's the time to talk about it. So I wonder, Angelica, do you think the best way maybe would be for you to share your screen and so that we can scroll through the rule text, or how should we go about doing this?
Do you have them up already? I can pull them up. Give me a second. I apologize. I didn't know I was going to share this.
I have them pulled up if you want me to just share my
that might be
screen.
easier. That way you can scroll through and yeah.
Okay. Yeah.
Thank you. Sorry about that.
Can everyone see my screen?
Yes.
Okay. So, all right, starting in subchapter A, we're starting with section 130.1. You'll see the underlined language means that it's new language. Before, the section was just called authority. Now it's called authority and applicability. What we're doing here is just, there are references to other sections or chapters within the occupations code in this rule text. And so what we're doing is just referencing them here in this first section, authority and applicability. So that's what you see here with 53, 108, 112, 116, and 601. And then we also have new subchapter B that talks about chapter 60, which is TDLR's procedural rules, and chapter 100, which are health-related programs. And so those are applicable to this program, the podiatric medicine program. And so we're just referencing those statutes in this opening section. So if there are any questions, just let me know. Otherwise, I'm going to move on. In 130.2 definitions, there's some cleanup here. It's just stylistic preferences, but we just did some crossing out there. The first real change comes in number 10, podiatric medical radiological technician. We clarified it here. Now it says a person who performs only radiological podiatric procedures under the supervision of a practitioner. New language, the term also includes podiatry X-ray machine operator. Also in the section practitioner, we added this second sentence. So the whole thing now reads, a person validly licensed by the department to practice podiatric medicine in the state of Texas. The term is used interchangeably with podiatrist and podiatric physician in this chapter. There are a couple of sections where it's kind of interchanged, practitioner, podiatrist, and so we thought it would be a good addition to just say that those terms are used interchangeably. And that's all we have for definitions. So moving on to subchapter B, I know it looks like there's a lot of crossing out here, but in an effort to streamline the chapter, that's what we're doing here. These sections for the advisory board are verbatim the same language that you see in Occupations Code 202. And so sometimes it's okay to reference verbatim from statute, but we just saw in this case, to streamline the chapter, we would just have a reference to Occupations Code 202. So you'll see that here in 130.20. You'll also see that in 130.21. All this original language is all the same language from 202.053. So we're just trying to streamline and just have a reference to 202. See the same thing in 130.22. We just have a reference to 202.054. You'll see the same thing in 130.23. The same thing in 130.24. 130.27 is not in 202, so we kept this section intact. So I don't think there are any changes to this. Yes, there's no crossing out or anything. So that section is unchanged. Oh, there is one change. So before we had subchapter G read, the department will establish an advisory board work group to review and make recommendations regarding continuing education requirements. And then in letter I, we said, opinions or recommendations made under subsection G will be presented to the full advisory board for discussion. And we thought it made more sense just to move this section, this letter I, up to right here. So really nothing's been deleted. We just moved some things around. In 130.28, that same applies to what I was talking about earlier, just referencing the occupations code. So that's what we did in 130.28. And that concludes subchapter B. So yeah, subchapter B, everything's pretty much the same. We're just trying to streamline it. If someone wants to get that information, they can go to occupations code 202. Subchapter C is a new subchapter. It used to just be temporary residency. Now we're doing temporary residency and other license types. We thought this made sense. There are other registrations, or I know we've talked about hyperbaric oxygen. There's a temporary residency license. There's a limited faculty license. And before, those types of licenses were scattered throughout the chapter. And so we thought it made more sense to have them all in one subchapter. So that's what we did here. We try to centralize everything into one subchapter. So in 130.30, it's mostly just some cleanup changes. You'll see shall is crossed out and replaced with must. This is an effort that we're doing in general counsel to use more plain talk language in our rules. I mean, instead of having legalese, we just trying to have more plain talk. So you'll see this example quite a bit throughout the document where we're just trying to use more plain talk language. And there's also some cleanup here also, just to make it more clear. Instead of saying successfully complete at least 90 semester hours, we're saying pass at least 90 semester hours. Here also, you'll see that successfully was removed a few times just because I don't think there's a way to unsuccessfully graduate. So we thought it was superfluous language. So we're just going to stick with graduate from a reputable college. Same thing applies to passing. You just pass it, you don't successfully pass it. So we got rid of successfully. There's some new language that we're using throughout our programs. So instead of just saying on a department approved form, we're now saying submit a completed application in a form and manner prescribed by the department. So just some cleanup, really non-substantive changes to this section. You'll see that again in the shall and must. Any questions on 130.30? Okay. 130.31. This is also just some shuffling around of how the section was worded before. Beforehand, it was temporary residency license, residency requirements, program responsibilities, and then it ended with license term. We thought it made more sense to start with license term. And so that's essentially what we did here. We just moved some of the sections around within this section. So everything's pretty much the same, apart from that cleanup that I was talking about earlier. If there was a chance to, or an opportunity to use more plain talk language, that's what we did. But essentially, this section is the same. It's just been reshuffled, essentially. Any questions on 130.31? And this is the original 130.31. One 130.32, temporary residency license, final year of residency. In this chapter, we streamline the section to increase readability and rearrange the order. So again, this is just doing some non-substantive cleanup and just moving some sections around. So again, all the information is still there. It's just been moved around to different parts to increase readability. Any questions on 130.33? 130.34 is a new section. Again, as I was alluding to before, there were some license types that either didn't have their own section or they were scattered throughout the whole chapter. So limited faculty license was one of those. Before, there was information on the limited faculty license in two different sections, in 130.40 and 130.42. So we thought it just made sense to put all that information together and give the limited faculty license its own section. So the information is still the same from where before it was just scattered throughout the chapter. Now all the information has been brought together into 130.34. Any questions on the limited faculty license? 130.35 for the rad techs. I will go ahead. I know we talked about it earlier during the work group reports, but I was wondering, Dr. Martin, maybe if you wanted to give some history onto this section to talk about some of the changes that we've made.
Sure. So basically, well, this program's been around for a while. The recent changes is we went to an online course and expanded the clinical requirements for podiatry assistants. It went from demonstrating one X-ray in an exam to maintaining a log showing 60 different X-rays. That online course, we pretty much underestimated the amount of time that was taking our assistants. And on the books, we had it at 20 hours. When we were able to look at the computer data to see exactly how much time was taken on the online course, and then when we estimated the time taken to complete 60 X-rays, the actual time that the candidates were spending was about 32 hours as opposed to 20 hours. And then we did a recent update 2 years ago, adding a lot of digital content as the profession shifts more from film to digital X-rays. And that expanded the online course, it expanded the student manual. And with the same number of X-rays, the amount of time taken to complete the course currently with 60 X-rays is approximately 38 hours. We also recommend a little different, and this is doesn't have to do with our requirements, but we recommend that more X-rays are taken in the 90 X-ray range to include ankle demonstration of ankle views clinically, and that would get us to about 45 hours that the podiatry assistant would be required to complete that training. Lastly, the change in the name to podiatry X-ray machine operator is to clarify so there's no mistake in understanding that the people that take this particular course are only qualified to take X-rays on podiatry X-ray machines. And I think that's a clarification that is important and in the future will become even more important. Those are the main points I would like to make at this time. If there are any questions, feel free.
Thank you, Dr. Martin. I think one other change is we're changing this registration from 1 year to 2 years. So that's just an additional change. So, all right, thank you for that. 130.36. Oh, I'm sorry. One more change to this RADSEC section is that, again, just in line with what I was talking about earlier, that it used to be in a different subchapter. So again, we're moving the RADSECs from subchapter D to subchapter C. And the same thing applies to this section, the hyperbaric oxygen certificate. Again, I think that was located in the subchapter D, but we thought it made sense to have everything in one subchapter. So that was moved from there to here. So this is new 130.36. I think most of this information is the same one thing. Also, just like with the RADSECs, this registration or the certificate is being changed from 1 year to 2 years. Any questions on hyperbaric oxygen certificate? 130.37, the nitrous oxide. This is, again, the same thing. It was located in a different subchapter, so we moved it here to subchapter C. So this is a new section, 130.37. Same thing applies with this registration. It was 1 year, but we're changing it from 1 year to 2 years. Otherwise, the information is essentially the same, apart from some cleanup language and some streamlining. Okay, now we're in subchapter D, Doctor Podiatric Medicine. In 130.40, you'll see here the name of this section was changed because, again, before this section used to have some information on a limited faculty license, but since we gave the limited faculty license its own section, we cross this out here and move that up. So in this section, other changes, again, you'll just see some streamlining, some minor non-substantive changes to the wordings, but for the most part, it is the same, apart from removing the limited faculty license language. Any questions on 130.40? 130.41. Slight edits to this change. Again, really the only change is right here, using plain talk language from shall to must. 130.42. This was the second section that had references to the limited faculty license. And so that section, that license type now has its own section. And so that's the only change, apart from, again, streamlining and using plain talk language. This was the reference to the limited faculty license that has been crossed out, but otherwise this section is the same. 130.43. Provisional license. In this section, I think it's mostly just streamlining, and this information is all the same, just making it easier to read, and the rest of it has been unchanged. Any changes on 130.43? Another change to 130.43 when I was talking about streamlining. So this section, the provisional license, there is a lot of duplicative language. So a lot of this language from this chapter is the same language that we see in 130.40. And so again, instead of having duplicative language, you'll see even here in this first sentence of 130.43, an applicant for a provisional license must abide by all the provisions of 130.40 except for. That's because literally before in the old language, everything, there was a lot of duplicative language between 130.40 and 130.43. So now we're just keeping this section limited to or specific to the provisional license. Instead of having the exact same language again, we're just keeping it specific to the provisional license. So that's another change that I wanted to point out. Otherwise, everything else is the same. And so you'll see here in the original 130.43, it's a long section. You'll see that it's crossed out, but that's because all of this language is the same language that we see up in 130.40. And so we didn't need to have duplicative language. So that's what you're saying here. (130.44). The proposed rules streamline this section and relocate the audit process to its own section. So for the CME, all this information, apart from streamlining, is the same. They're non-substantive changes to this section for the most part, but originally in the current rules, this section includes the audit process that TDLR implements, and we thought it would make more sense to break that up. So you'll see 130.44 is essentially the same, and then below 130.44, we'll have new 130.45 that talks about 130.45 that talks about the audit process. You see here's the original language where the audit process was a part of 130.44. We broke that up, and now we have 130.45 continuing medical education audit process is its own section. And this information, apart from some streamlining, is the same as it was before. So no substantive changes to the audit process. Any questions on that? So since we inserted a new 130.45, we had to shift everything down one number. So this section was continuing medical education, exceptions and allowances. So that got pushed down to 130.46. And in this section, there was just some streamlining, and everything else is essentially the same. Again, since everything got pushed down, inactive status was 130.46, but now it got pushed down to 130.47. Again, there are some, there was one public comment when we first had the notice of intent to review back in 2021 or early 2022. And that comment submitted did have a question about whether or not there was a cost to switch to inactive status. And so while this section is essentially the same, we did insert this language saying right here that a practitioner may place a license on inactive status at no cost. So that addresses that public comment that received and answers that question that you can do that at no cost. We also inserted this language right here on C, just to clarify, just like with a normal license, you have to renew it every 2 years, and you have to do that as well, even if you're on inactive status. And again, that's at no cost. So otherwise, this section is essentially the same. Any questions on inactive status?
Mr. Parker?
Yes.
On the application, I believe that is on the website, it has a application fee of $530, parenthetically non-refundable. So is that going to be changed online if I'm correct?
If for $530 to change to an inactive status?
It's under inactive status on the website. It says $530. Non-refundable.
Okay.
Yeah, we would change that.
Yeah, if there's something wrong on the website, we can definitely make a note of that and update that.
I just want to make sure. I just want to make sure that the application is consistent with the verbiage here, if I'm correct.
Okay, we will definitely look into it and make sure that the website is up to date.
Yeah, we'll
Thank
double
you.
check the programming as well to make sure when they do that, if that's done online, that would, there would be no fee to complete the transaction.
Thank you. This is hyperbaric oxygen. Again, this is where it was originally. We moved it up to subchapter C. Voluntary charity care status. This language is essentially the same as it was originally. It's just some streamlining. Otherwise, it's the same as before. Non-substantive changes. You'll see nitrous oxide crossed out here as well, but that's just because we moved it up to subchapter C. Okay, on subchapter E, practitioner responsibilities and code of ethics. For 130.50, we have the proposed rules remove language regarding the purpose of this section and streamline the rest of the section to make it easier to read. So you'll see these examples of streamlining here in letter C. There was a sentence here about the purpose of this section. In an effort to keep the rest of the chapter uniform, we don't have a purpose for other sections. And so we just decided to remove this section as well. So not taking anything away from substantive rules. It's just getting rid of the purpose of this section, and that's because we don't have a purpose of this section in any of the other sections in this chapter. So we're just trying to keep uniformity. Any questions? In advertising 130.51, the proposed rules streamline the section and remove language relating to certifying boards that are not recognized by the CPME. So you'll see some streamlining language here. And then this section F, each certifying board that is not recognized by the council. This section was on advertising, so there was a little confusion as to why this section was still here. I remember having this conversation with Dr. Hemmett Macon when he was still with the agency, and we thought that maybe this was left over from when you guys used to be your own independent board, but we came to the conclusion that it wasn't really applicable anymore, and so we went ahead and got rid of this language here, talking about a certifying board that is not recognized by the CPME. Also, there were some things here, such as requiring that the certifying board has a permanent headquarters and staff that is probably outside of our authority as a regulatory agency to make sure that they have a permanent headquarters and staff, especially considering that in this program, we don't license the facilities, we license the individuals. And so we decided to just remove this section right here, this letter F. Any questions on that? In 130.52 medical offices, this section was repealed as well because I just made the point a second ago after discussion. We don't have the authority since here we regulate the licensees, not the facility. And so this would be something that's outside of our authority with the medical offices. And so this section was repealed. Any questions on medical offices? 130.53, you see that this is crossed out here, but the rad techs were moved up to subchapter C, and the rad techs, we already had that discussion, so I'll keep scrolling through this. (130.54) records. The proposed rules streamline the section and make it easier to read. So again, you'll see some plain talk language updates throughout this section. Otherwise, it's essentially the same. You'll see here that this chapter in particular has some pretty thick paragraphs. And so to make it easier to read on the licensee, instead of having these big block paragraphs, go ahead and have list form. So that's just a stylistic change to make it easier to read. Nothing substantive was changed. Again, here you see this paragraph G is a huge paragraph, and so just to make it easier on the reader, it's broken up into smaller bits to make it easier on the eyes, but all the information is still in there. Any questions on that? Okay, moving on to 130.55, Practitioner Code of Ethics. The proposed rules add language to the section and establish that treatment must be consistent with best practices and standards observed in the podiatry community. So we did add, everything else is unchanged in this section, but we did add one letter G to the bottom when it comes to the code of conduct or code of ethics. A podiatrist treatment of a patient must be consistent with the best practices and standards observed in the podiatry community and must be performed with the same level of skill required of a reasonably prudent podiatrist practicing under the same or similar circumstances. So this is kind of similar to language that we see in different programs just regarding the code of ethics, just to make sure that we're performing on a reasonably prudent standard. Any questions on that? Okay. 130.57, sexual misconduct. The proposed rules streamline the section to make it easier to read. So in this section, again, you'll just see, for the most part, it's left intact, but there are some streamlinings, like right here. Number 4 was another big paragraph. So just to make it easier to read, we listed the information in list form, but otherwise everything else is, all the information is the same. So just streamlining the section to make it easier to read. .58, the proposed rules streamline the section to make it easier to read. So again, here you'll see again kind of a large paragraph just to make it easier on the reader. Instead of in paragraph form, we have it in list form. All the information is still there and unchanged. But then you also have some streamlining and using plain talk language. And you'll see another example here. Instead of in block paragraph form, we have it in list form, but the information is the same. Any questions on that section? 130.59, the proposed rules streamline the section to make it easier to read. So again, it's going to be more of what we were just talking about. Most of the section is intact and unchanged, but you will see some examples of, instead of having the information in a block paragraph form, it's easier to read in a list form, but the information is the same. Fees, 130.60. So we'll see some updates here because we were talking about how for the hyperbaric oxygen certificate, we're moving it from 1 year to 2 years. So you'll see there's a cutoff date from when that happens. So after that date, it'll change from 25 to 50. Same thing for the nitrous oxide registration, changing from 1 year to 2 years. So you see that reflected in the price. And the same thing with the rad techs. Being changed from 1 year to 2 years. So the price increases from 25 to 50. Any questions on fees? 130.70. I think the only change we have here is just the streamlining and using plain talk language, shall to must, shall to must. Otherwise, the section is the same. You'll see again here, instead of having some information in this paragraph form, we listed out just to make it easier to read. Any questions on 130.71? Okay. For 130.72, administrative penalties and sanctions, it's essentially the same. We just added in this qualifier saying if a person or entity violates or attempts to violate any provision of the occupations code, we can take action against them. And then again, some cleanup language using must instead of may. Any questions on 130.72? 130.73, it's just streamlining the section to make it easier to read. So again, the information is the same, but you'll see here in A, again, we have a huge block paragraph just to make it easier on the eyes and easier to read. We have the same information listed here in list form. Same thing with this information. Instead of having it in block form, we list it out here to make it easier to read. But the information is still the same. And that's the last section. So again, a lot of this is just some cleanup, making it easier for the licensees or the license holders to read the information. We update some plain talk language and move some sections around, but for the most part, the information is the same. And that includes the discussion of rules from me. If anyone has any questions, I'm available.
Okay. Any questions for Mr. Parker?
John, I
And-
just
Go ahead.
quickly, excuse me, Mr. Chairman, I just want to say thank you. That was very thorough. I know there's a lot in there, so thank you for that. Great job.
Yeah, we like shorter paragraphs. I have lots of textbooks that I want to send you, and you can work some magic on this. Okay, just for clarity, is everyone comfortable as this goes as one motion? And to be clear, and Helga, this goes back to TDLR and then to Texas Register, correct?
So my understanding, John, and correct me if I'm incorrectly, we just need a motion today to publish these, the Texas Register public comment. So
Okay.
they'll be comment and then come back.
Okay. Gotcha.
That's
Okay.
correct.
Is everyone comfortable with lumping all of these in, all the subchapters that Mr. Parker just went through with us? Everybody good at doing that as one motion, correct? Okay. Anybody want to make that motion? Recommend accepting those revisions.
So moved.
Yeah.
So I had Dr. Lunsford and I heard someone else on there. Say you,
Brown.
Mr. Rossnes. Oh, Dr. Brown. Okay. And then we'll take a roll call vote.
Yes. Just to verify, the motion was made by Dr. Lunsford and seconded by Dr. Brown, is that correct?
Correct.
Want to make sure. Thank you. All right. Leslie Campbell? Approve. Dr. Brown?
Approve.
Dr. Lunsford?
Approved.
Dr. Martin?
Approve.
Dr. Peach?
Approve.
Kristen Lucky?
Approved.
Maria Hernandez, if you can hear me. Okay, hands up, awesome. And Selena Terrazas?
Approved.
And presiding officer, Dr. Trevor Molly.
Approved.
Motion passes.
Okay. Thank you, everyone. And that was really, that's a lot of work. And so I'm glad y'all made that easy. Mr. Parker made that easy for us. That was agenda item H. Any recommendations for the next board meeting? We'll take those now if you have them off the top of your head. If not, of course, we can send those through email and happy to add them through agenda as before we get our next agenda going. We don't have a set date or time for the next board meeting that I'm aware of. Is that right, Aunt Helga?
Correct. We definitely want to wait for the public.
May 13th, 11:26. Thank you very
Dr. Martin,
much.
if I may say something.
Okay.
I mean, Dr. Molly. I just want to thank
call me
Dr.
whatever.
Yeah, Dr. Martin for his expertise in putting together the whole history and the breadth and depth of the radiological technician package. I mean, he is Mr. Radiological or PXMO, Podiatric X-ray machine operator, genius. He built that program and is a great resource for anybody should they have any questions about that license type.
Absolutely. And kept it clean and neat the whole way where it's not, it's something since he started, we never had to go back and like revise or clean it up or update it. It's one of those things that he built that is just, it just runs itself. I mean, he does all the updates, but it runs itself. And I remember when he started that, man, that was a couple of years ago. So that was
Yeah,
an awful lot of work.
Thank you. You're very kind.
That's good. We'll do a thing about how to get your video on for Zoom conferences. We'll add that to your radiology program.
Yeah, if you could send some kind of tutorial so I could study it, that'd be great.
I love it. I love it. Okay. Anyone else? Final comments? Perfect. Okay. Thank you all so much for your time. I appreciate you. And 11:27 Monday, May 13th, we're adjourned.